Appeal, Part Heard, in the matter of Zedra Trust Company Limited and the Factual Limited and others.
Yes, good morning, Mr Chasty.
My Lord. May I briefly just outline what I propose to do this morning?
Yeah, just take it, just give me a second, if you don't mind, because I have read your document, and but not in huge detail, and I just want to make sure that I have I really want to make sure I can give full attention to your submissions. Right, I now can.
My Lord, for my part, and obviously the Lords will have any questions that you have and I'll endeavour to address them, but for my part, I propose only to address the issue that arose yesterday and what I call the new point in the sense of the new pleading point, as I would describe it. Mm-hmm. And our position, my Lords, just to restate, is that we oppose the granting of permission to raise this new ground of appeal. We say that 2 of the 3 criteria in the Das Singh case have not been met, and we invite you therefore not to...
Sorry, I misunderstood the case you were referring to. Which case is this? This is the Sue case, is it?
No, this is the Singh case, my Lord. It's in the...
The one that I said I was in, which I wasn't.
No, that was the other one that you said that you were in, and it slightly confused me when you said that you were in it. It was a QB case, the one about...
No, I hadn't got its name in front of me. I was in a case called Sue, but it was a different Sue.
No, I think I'd forgotten who the judge was, but it was a Queen's Bench decision in that Sue case.
Yes, okay, yeah.
But no, this case, my Lord, is the case of Singh, Das and Singh, the case that simply sets out in 4 short paragraphs the position of the Court of Appeal in whether or not to allow a new point of appeal to be raised.
This is the Lord Justice Haddon Cave case?
Yes, Lord, yes.
Yes, okay, yes.
So we say that we rely upon that and we continue to oppose.
So which, just for my note, which are the 2, you said 2 out of the 3?
2 out of the 3. Well, the third is whether or not we could be protected in costs. I don't think there would be any, if that means simply a costs order in our favour,
yeah,
I don't think we could quibble with that. So it would be the question of adequacy and time to deal with the point and the absence of having not acted to our detriment.
Well, you haven't done, if I may say so, very well about saying you haven't got adequate time to deal with it, when overnight, in the most extraordinary, if I may say so, with the most extraordinary assiduousness, you have produced a document with, what, 15 new substantive paragraphs?
My Lord, I'm going to come to that document, obviously.
For which you are to be commended, Mr. Chase.
I think rather than stand in front of Mr Macpherson, the person who probably is entitled to the most praise, if praise was to come, would be Mr Macpherson. But my Lord, I will come to that and explain our position in respect of that, because we're not saying that is necessarily the final position. I will explain what I mean by that in a moment.
So there were 3 points. Protected in costs, yes you can. Adequate time to deal, no you can't. What's the third?
Well, the second point is whether or not it's a reverse. The other party has not acted to its detriment on the failure of the earlier omission to raise it. What I'm saying in a sense is that because we didn't appreciate that was a point that was going to be raised, we didn't prepare a draft save until last night. So it's part of the same thing, really.
Which is part of A, isn't it?
I'm sorry?
It's really part of A.
Yes.
It's the extension.
That's what I'm saying. In terms, therefore, of what we would invite you to do in relation to this point, as I say, my lords, we invite you not to allow it. my Lord Master of the Rolls has indicated that the court may nonetheless feel justified, if not obliged, to make some observations in relation to the current state of play in respect of the pleadings. My Lord, of course, if my Lords feel that is the course to take, then what that will mean is that the parties will take that away with them, and each side will do, as it were, what they think is the right course in respect of those observations. As I said yesterday, it may be that the appellants feel that they're so emboldened they'll go and make another application to strike out on the grounds that my Lords might articulate, or alternatively, and possibly by way of answer if they did that, we might then seek to apply to amend. But those are matters that would be best dealt with by the judge at first instance to deal with these sorts of applications. And furthermore, although the fact of the flotation has come in and out during the course of this appeal, neither side has addressed the impact in any particularly meaningful way. And it seems inevitable, if this action were to continue, that both sides would probably wish to revisit in some form or other the impact of that event. And so the pleadings would probably be being looked at again by both sides. So that's what we would invite the court to do. In terms of moving on, there are two aspects of the submissions that I wish to address. The first is I can probably do reasonably quickly, and that is to take my Lords to the existing pleadings to show how certain issues which have been raised in the draft produced over tonight already feature in the context of the existing pleadings. It's a little laborious way to do it, but I hope you'll forgive me. I'll try to do it as quickly as I can. The defence in the...
Well, what's the second point? Sorry, you
the
said
second point, I'll come on to this document that I produced, we produced overnight. The defence, which you will find on this point at page 135 of the bundle, at paragraph 54.3, says at all times since
just wait a second. 135.
135 of the hard copy, I assume it's the same. It's the defence at 54.3.
Yes, got it.
And one of the points is that all dilution has occurred in accordance with the Companies Act, the terms of the SHA, and the company's articles. In respect to those last words and the company's articles, that led us to serve a reply. First of all, an RFI, I think, in terms of chronology, that might be right. We served an RFI, and that's in the supplemental bundle at page 61. And requests 16 and 17 raised this question in the context of what I've just shown you. And we said, 16, please state whether it's the respondent's case that any of the share allotments were made pursuant to the director's powers in the Companies Act and in accordance with Article 3.1 of the Articles. Please state in each case whether the respondent's directors decided not to offer the relevant allotments to Zedra on the grounds that the special shareholder majority, as defined in the Articles, had determined not to make such offer in accordance with Article 3.2. And then some further details. And then at 16 and 17, you can see that it says the petitioner is referred to the respondent's rejoinder, which addresses this request. The petitioner is referred to the respondent's rejoinder, which contains such information as the petitioner is entitled in respect to this request. At the time that we were before His Honour Judge Eyre, there was no rejoinder because, of course, they needed permission in order to serve such. The reply, I should draw your attention to, is also in the supplemental bundle at paragraph 40 page 40, begins at page 40. And if you go, please, to paragraph 30.
Sorry, can I just understand
Forgive
that
me.
chronology?
I
The
think
answer to the request is referred to the respondent's rejoinder,
Yes.
and this is June 19. Was the rejoinder attached as a draft?
My lord, I'm struggling to answer that question, I'm afraid. And I know, looking at the application, that my lord can see at page 4 that the application had with it a draft of the rejoinder. And it says, as the court will note, the draft rejoinder addresses a single paragraph of the reply. The respondents seek permission to file a rejoinder for the sole purpose of pleading out the reasons why the directors were not obliged under Article 3.2 to allot shares to the petitioner as alleged in paragraph 30. I'm struggling to answer my lord's question directly. I think there may be a divergence of view as to when that draft of the rejoinder was first produced.
The response dated 19th of June would make no sense, 14th of June, sorry, would make no sense at all unless there was at least a draft. And if you received it without the draft, I imagine you'd have asked for it.
Well, the application notice is dated the 14th of June.
No, the response. Sorry, I see. Oh, I see. So the response to the request for further information is dated the 14th of June. And you say the application...
The application is dated the 14th.
So you must have had the draft rejoinder.
The rejoinder... the rejoinder is dated it's signed, dated the 17th of February.
Yes, but that's because they needed permission of the court.
Yes.
They got it in January from the judge.
Yes.
But they issued their application seeking either a strikeout or permission for the rejoinder on the 14th of June 2019, and presumably the draft rejoinder was attached to the application.
I don't dispute that.
So you did have you had the request, the response to the request, and the draft rejoinder at the same time.
Sorry, I'm getting different answers here.
I mean, that would seem to make sense, really,
It
wouldn't
makes no sense at all to refer to a document that doesn't exist. You would have said, hang on a minute,
Yeah,
where's the rejoinder?
The precise date that it was delivered, my lords, I don't know.
I don't mind about that. It isn't a meaningless reply, is the short point. It was obviously referring to something
I take my lord's point.
was accessible.
Take my
That's the only point I
Take
was
my
interested
lord's
in. Yeah.
The-
So then we've got the rejoinder, which we assume is in the same form as the draft behind tab 9.
The rejoinder is at page 65 in
Yeah.
this bundle. I should just show you first of all the reply. The reply is at page 47, and it says, as to paragraph 63, the directors had the obligation under Article 3.2 to allot. I think that's probably slightly,
Sorry, which paragraph?
sorry, Mother, 30 on page 47. That should probably say offer to existing preferential shareholders in proportion to their existing shareholders. The company didn't notify Zedra that Article 3.2 didn't apply, nor the reasons why. And then jumping back, as it were, to the rejoinder, which is...
Hang on a second. So you pleaded that the directors had the obligation under 3.2 to allot to existing preferential shareholders in proportion to their existing shareholdings. And the company didn't notify Zedra that Article 3.2 did not apply, nor the reasons why. Right?
Correct.
So slightly half-hearted, but yes, I see.
But I'm bringing it into play at least, I can put it that way.
Yeah, bring it into play. And then you go back to where?
The
65.
rejoinder at 65. And as the application itself notes, the rejoinder is purely to deal with that paragraph 30. And it quotes paragraph 30 of paragraph 3 and then says that for Article 3.2 didn't apply to any of the share issues as defined in and enumerated under 41, in particular in relation to, and then it sets out in respect of the majority, but I think it's fair for me to say not every single transaction that's in the petition, the position adopted by the respondents in relation to why Article 3.2 was disapplied.
Mainly because it was disapplied by the written consent of the special shareholder majority, is that right?
Well, this is another reason why our draft couldn't be described as being final at the moment. There is some complication in relation to different sets of articles being generated at different times and not necessarily filed on time. And it's not always easy to follow precisely where the articles fit in, because you will see, for example, my lord, at 66, that number 3 refers to a special shareholder majority. Number 2 refers to a fundamental shareholder majority. The articles that are in the bundle, which are the 2011 articles at 3.2, which is at page 118, refer to a special resolution.
But have you asked for, have you made an RFI of what these different formulations mean, or did you say to the judge when they asked for permission to serve it, we don't understand what this is talking about?
No, it's fair to say that the rejoinder effectively went through on the nod. I think it's fair to say that.
You agreed to it?
We agreed to the rejoinder.
Right.
But what I say, my lord, is, of course, those are the assertions, those are the allegations, and it's in play. So, my lord, I just draw these to your attention to show that this question of Article 3.2 is already an issue in the existing treaty.
I just want to be quite clear about that. It's not an issue in the petition. You don't allege in the petition that there was any, but you say in the points of reply, referred us to, I've got this right, well, paragraph 30, this is what my lord referred to as half-hearted.
Well,
you don't actually say that there was you refer to Article 3.2 of, and you're referring there to the 2011 articles.
yeah.
But I think you knew that, I mean, you'd been invited, Zedra had been invited to vote on the adoption of new articles. I think you even plead that.
Well, there are all sorts of factual issues about the extent of our knowledge and information as to the
No, but I mean, in terms of new articles,
yes,
that required a special resolution. Your Zedra was given notice of the proposal to adopt new articles. Now, you may have complaints about what you were or weren't told about the articles, but I mean, you do know that new articles have been adopted.
My lord, we would need more time to finalise our position.
Well, I mean, for example, paragraph 27 of your petition, you actually refer to the new article.
Yes, yes.
Adopted on the 7th of August 2014, which is before any of these share issues.
I think some of the articles, or the articles that the rejoinder might be referring to, would be articles of 2016. But,
they may be,
but
you're right that they don't tie up at all. Not even number 1 does, because it refers to a provision that doesn't exist in the 2011 articles. But
to be clear, my lord, I'm not for this purposes of this position that I'm just seeking to explain, taking a point about different articles applying.
No, but it's important because
it will be. Yes.
It is important because what Zedra's rights were at any time are determined by the articles at that time.
I understand that. What I'm saying is that they are asserting that they've acted in a way in accordance with the articles.
You're not asserting they didn't.
Well, we haven't put in a surrejoinder in relation to the rejoinder.
It's no part of your petition, but anyway.
My lord.
Yes.
My lord has the point where it is, at least in the game, as it were, and I use that phrase deliberately. It's in the replies. I accept that. I don't think I can advance that point any further.
But the trouble also is, isn't it, you're referring to articles which, if I may put it this way, your client knows had been superseded by the relevant times.
Well, that would need to be addressed. I accept that again. And that's another reason why this document, just turning to this now, this document that has been produced overnight would need to be finalised. But can I just explain, can I move on to this document now in terms of our position in respect of this? Because I'm not making an application to amend. I'm not making an application to this court today to amend in terms of this draft. First of all, I don't think that would be realistic. I don't think my lords would welcome or invite me to make such an application. And furthermore, whilst this has been produced overnight, it's right to say that we've not had the opportunity of addressing these matters with our client. And the question of signature of a statement of truth, for example, is something that I couldn't commit to now in a way that I would be if I was making an application to amend if it was granted. So it's here to show the sort of document, if I can put it rather vaguely like that we would have been considering putting together if this had been raised in front of His Honour Judge Eyre, this what I call new point, and Judge Eyre had said, I'm minded to strike out for the following reasons, which might or might not have reflected some of the observations that the Lords have made. And I would have stopped then and said, well, please don't do that. It's a case of Sue, which, although the Master of the Road wasn't here, it is a Queen's Bench case that we rely upon. And give us time to go away and do it. And that's I put it deliberately like this. This is the sort of document that we say we would have produced.
I mean, I find that a little bit unsatisfactory, Mr. Chasty. I mean, I understand you can't commit to the statement of truth in the sense of saying that you've had an opportunity overnight to go through line by line with your client to make sure that what you're saying is true. But I assume you have instructions to put forward this document as the explaining the nature of the case you would like to put in the light of the new point raised.
Yes, I can go that far, but what I can't say is that this is the definitive version, because there may be, and we haven't had time to do it, it may be that there is some further refinement purely in terms of such matters as the prevailing articles at the time and so forth. We've endeavoured to put some information in that we know at the moment. When I say we, I mean the lawyers effectively know at the moment about some relevant, potentially relevant aspects of some of the transactions that we've referred to. But we would wish to go through that exercise.
Would you accept, Mr. Chasty, that what is fundamental to this new pleading is what you now describe as the acceptance obligation? In commercial terms, that's really what is new. I'd probably be. I think my lord might have pushed me more to say that there was more new in it. I mean, in a nutshell. There's lots new, but substantively, if we come to look at the paragraph 44 allegations, what is now new is said that there was an acceptance obligation and an offering obligation,
yes,
whatever you call it.
Yes.
But I mean, acceptance if there's an offering obligation and they say they would never have offered you anything, then that's not very helpful. But the acceptance obligation is very critical, because if it's right that everything you plead would have made an offer at the same price, you did want to be involved, and there was an obligation for them to accept, and they didn't, then you may indeed have lost a vast amount of money which you claim. Some by hook or by crook, and I'm
yes.
not now looking at the technicalities of the 994 petition.
Yes.
So what I'm really asking is, do you accept that that is pretty fundamental to this new pleading?
It's. We don't say it's new. We say it's a. What my lord might. What I would say is it perhaps a better expression of what we had already been saying, because what we were already saying was that we should have been told about the opportunity to invest further, and if we'd been told, then we would have sought to participate. And we said, and they would have accepted our participation. And they just came back and effectively said, prove it.
Yes, I did, but what I put to you yesterday, I think several times, my lord as well, was that that was commercially naive, because everybody knows that the board did not have any obligation to accept a particular investor in a situation of this kind. And so, unless they did have an obligation to accept a particular investor, they were at liberty to recommend one investor over another at will. And what is new about this is that you're suggesting that there was such an obligation.
To that extent, but I can see why my lord would say that that was new, in the sense that, does my lord have in mind that part where we say that there was no entitlement on frivolous, non-commercial grounds to reject our offer?
Yes.
Well, I think it's the whole, isn't it, of paragraph 21C of the new pleading. As my lord said, the acceptance obligation is preceded by your pleaded notice obligation and then offer obligation. So it's a series. That's...
My lords, my response would be, as I've said, to articulate or to characterise that aspect as a refinement of the existing pleading.
Yes.
The other point, of course, is we are bringing in 3.2, but my lords have that, I don't think. We are bringing 3.2 into the body of the petition,
How, we can't really do that, can we? Because Article 3.2 wasn't it, I mean, it had ceased to apply by 2016.
That's where I've said there was a similar. This is the problem. There was a similar 3.2.
Well, there was. I understand that because I can pick that up from the references, but it's and it was still, I think, 3.2. It would appear.
And that's
but
why
we
this
don't
isn't
know
final, my lord.
what's in it.
This is why this was not final. I can be
No.
quite candid that Mr Macpherson and I had not appreciated. There was a lot of work went into this. That we couldn't plead the 2011 articles for the purposes of this. So it would need to be
But what
changed.
I mean, the
but
problem
it doesn't
is
change
that,
the substance of the point. Sorry, Lord.
I mean, even under your existing, even under your existing pleadings and the references to Article 3.2, there was nothing pleaded to suggest that Article 3.2 applied to the issues that were made.
Beyond paragraph 30.
Well, but even in paragraph 30, because Article 3.2 in the 2011 articles has various exceptions.
Oh, yes.
And
yes.
you don't plead anything to suggest that the exceptions didn't apply.
Well,
so I don't know how you can say Article 3.2, even assuming that was the applicable one, did apply.
That assumes that we knew that the exceptions applied, or that the exceptions could apply.
I mean, yes, well, it's for you to make your case, isn't it?
Well, but not by necessarily.
I mean, you can't just say
preempting something that we don't know in terms of.
Well, I don't know anything about what you. I mean, you say you don't know. I mean, I don't know anything about what you know or don't know, but I would assume you know details of the issues of shares. You know who they were issued to. You know what the consideration provided was. You have the means of finding that out. You know what the article said. At the moment, I don't really, truthfully understand.
Is my lord saying that we had that information at the time?
No, now, when you're pleading your case. That's the point. Yeah. You had it when you issued your petition.
I'm not.
And you've had it, or you've had the means of knowing it, at least since then. So you could plead, if there is a case to be made that all or some of those shares were issued in breach of the terms of Article 3.2, in whatever form it was, you were in a position to make it. And conspicuously, you didn't make it in your petition.
Yes.
And you sort of have a bit of a shot of it in a half-hearted way in the points of reply. Now, I deduce from that, frankly, that there isn't a runnable case on Article 3.2.
Well, I would merely say that, my lord, I'd invite my lord not
you
to
haven't
make
put
that
forward
conclusion.
anything to suggest there was a breach of Article 3.2.
I'm still purely in the pleading stage.
No, but you have the information available to you to plead. You had it in 2019 whenever you issued the petition. and you've had it ever since then.
Well, but that, Lord, I think I'm trying to address it. I think at the moment, Lord, that would merely be that, in order, as it were, in the reply to have anticipated what was going to be said in the rejoinder.
No, it was for you. If you were alleging a breach of Article 3.2, it was for you to allege it, and you couldn't ignore the exceptions to 3.2. You'd have to look at the terms of the issues, have to look at the articles, and then plead your case that it was a breach.
Well, my Lord, different people could plead this in a different way. If somebody says Article 3.2 applies, and we were not able to exercise our rights to pursue it, at the very least it's implicit in that, if you're making a positive assertion that 3.2 applies, that it's not been otherwise excluded. They then come back and say, we need to put a rejoinder in to address this allegation, to say that it doesn't apply for the following reasons. And that then completes the circle. So they know that we're saying it applies, and we know that they're saying it doesn't apply for various reasons. So, Melissa, as I say, I'm not putting forward this document as the final word. I'm putting it forward as an indication of what kind of document we would have been producing if this had gone, if I might say, the course that it perhaps should have done, rather than the way that it's developed.
Well, I started all this by asking you whether you accepted that what was fundamental to this was the acceptance obligation, but I think I should have said the Article 3.2 obligation and the acceptance obligation.
Yes.
But surely you will accept, having heard what my Lord has put to you, that this is at least a very significant reformulation of the way the case is put in the reply. And if that were, I mean, it founds on the Article 3.2 obligation and the acceptance obligation. And if those were demonstrably not open to you, then you wouldn't be getting very far with this. I'm not saying they're not. I'm just saying if they weren't. I mean, I'm trying to.
They are important links in the. I accept that. There are important links in the chain. Yeah. But I do wish to keep stressing that we have produced this overnight under quite some pressure of time, in a way that we would not have been required to do if it had been dealt with in the way that I suggested.
But it's slightly your fault, because you've had 2.5 years to put forward an acceptable petition, and you knew that you'd been facing a strikeout application time, 2 years, and customarily when people face a strikeout application, even if the strikeout application adopts a slightly scattergun approach, and some of them do, they look at their pleading and try and make sure that it's absolutely bomb-proof.
Well, Lord, I would not accept with respect the suggestion it's partly our fault. We were faced with an extraordinary application in front of His Honour Judge Eyre, raising, with respect, hopeless points that to some extent have been pursued, but without any great resistance to observations from Lord Justice Richards in the first 2 or 3 minutes of the appellants opening their case on derivatives, reflecting loss, human rights, all sorts of, if I may say, bad points. And the point that was made in front of His Honour Judge Eyre was, as we understood it, and as we say His Honour Judge Eyre understood it, was very narrow. We then had a CMC that was lined up after that. But for us to go away and say to ourselves, we need to spend, and our clients need to spend a lot of time and money and instructing our lawyers to then anticipate that something that the appellants themselves don't seem overly concerned about.
There's a lot of money at stake here, though.
There is money, yes, of course. Of course, but, well, my Lord, I gently, if I may say, and obviously with a degree of hesitancy, but wouldn't accept the suggestion that it was entirely, or even respect partly our fault in the sense of where we are today. But my Lord may...
Well, we're not, we may be talking about that when it comes to costs, but we're not talking about that in terms of your application this morning. Anyway, we've got the point that you're not applying for permission to amend. This is an interim document. Do you want to, just to indulge the court, by explaining, or for my benefit, how you say that this pleading sustains the 3-2 obligation and the acceptance obligation in a way that is now clear and robust in pleading terms?
Well, we say, my lord, that I'm not going to take you through it paragraph by paragraph. I'll answer it this way,
we've actually read it. Well,
exactly.
Some of us have read it. I'm not sure everybody has read it.
What?
I read it before you.
Yeah, my lord read it before me, and more carefully.
We say what it does, my lord, is it sets, first of all, it sets out certain factual allegations. It beefs up, as it were, certain factual allegations in respect of the position of Mr Cookson as an individual and the role that he was expected and entitled to expect to play in the new company in which he was investing. And it also beefs up, as it were, the importance of what he was bringing to the party, which was my protein, in terms of what, of course, has been the roaring success for THG as a consequence. We plead expressly at Article 3.2, which is clearly important, and we say we plead it sufficiently to bring it in properly into play.
But not the exceptions to it.
I'll come back. I'll come back to the acceptance. The acceptance point, I'll come back to. We then say that certain rights are to be construed against, and this is the my protein point, certain factual background matters. And linked with that, we say...
Can we just pause there? You're saying that in 20B that the shareholders agreement and the articles fall to be construed against various matters there pleaded. Now, so far as construing articles are concerned, the authorities establish, don't they, that you in general don't look at the sort of surrounding circumstances that would normally, that might well apply in construing an ordinary bilateral or multilateral contract. I mean, is it Bretton Seymour?
My lord,
and I think there's been subsequent cases.
my lord, the difficulty is that I'm sure as we go through this, each one of my lords will find a point.
Yes, all right. Well, I just wanted to raise that.
No, I understand, my lord.
I mean,
and again, that is a point that might require more reflection than we've had overnight, because it's a point to make in terms of introducing these factual aspects of the background in order to lead to an important factual premise, which is that the shareholding which Zedra has is not purely an economic interest in terms of the number of shares, but if a shareholder has a certain percentage of shares over and above a certain figure, then they carry with them certain entitlements. So, for example, the 5% threshold and the 10% threshold carry with them certain entitlements in terms of information and in terms of involvement with article changes and so forth.
Yeah.
And if one took it, therefore, to an extreme, the position that the respondents might adopt to an extreme, those rights, those entitlements, or those positions are meaningless essentially, because you could reduce, or a situation could prevail whereby his percentage is reduced to 0.5%, and so any rights that it had been intended that he would have had as a 5% shareholder or a 10% shareholder, when he brings this valuable asset to the party, to THG, are just simply lost. And query to what extent it can be argued that that was actually intended. So then, my lord, we go on to argue questions of construction, and in particular we focus, although my lord's observation is noted in respect of what we said about the factual matrix for the purposes of construction, what we focus on at 21 is the construction of the SHA in terms of the information obligation and covenants obligations. Then, my lord, we go on to argue, in addition to express terms as matters of construction, we go on to argue implied terms, and we take, my lord, at 21C and 3, the acceptance obligation as an implied term. That's where my lords find that. We also assert that those matters can be described for the purposes of 994 as unfair, as legitimate expectations and understandings which prevail.
But, well, let's take it separately. You're saying that into the shareholders' agreement there should be implied rights to be offered shares.
Yes.
Which are not contained expressly in it.
Yes.
So you've got a sort of commercial document.
Oh yes.
Setting carefully drafted.
Yes,
no
I accept.
doubt. And you say that there is scope for implying something which has not been agreed expressly.
Yes.
And is that notwithstanding the point which I hadn't fully appreciated till I read Mr. Mouchenson's judgment, that actually your client's deed of adherence to the shareholders' agreement excluded the company's covenant to offer shares round?
My lord, the answer would have to be yes.
Because the shareholders' agreement...
I take the lord's point. The answer would have to be yes.
I mean, that is to introduce an implied term which effectively contradicts an express term, doesn't it?
Well, this is, with grace, this is the difficulty of this exercise that I'm being faced with.
I understand that, but I think
I'm seeking to
yes.
maintain a position, not seeking to make that application to a name. So I'm not facing the test that I would need to meet if I was making an application which is effectively summary judgment type test. Is it frivolous or vexatious what we are seeking to advance in terms? That's the test as to whether or not I would get permission to amend.
Well, is it legally sustainable?
Well, is there a real prospect?
I mean, it may be said against you, Mr. Chasty, particularly in the light of the point my lord has just made, that this is the demonstration that your petition was obviously bad, that when you try to elucidate it and explain it by reference to the details, you fall into the need to overtake an express term that you were not to be, they were not to be required to offer you shares, with the implied term that they were. And that, as we all know, those of us who have read Wood and Capita and all the other cases in the Supreme Court, is something, and even Bayliss, if one went that far, we know that is something that this court just does not any longer countenance.
My lord, I am not putting forward this document, I need to keep stressing that, as the final word.
Well, it's not helpful to stress it, because you're putting forward the document in answer to a point that this petition is and was always obviously bad. Hopeless was the expression used. Now, I know you object to them raising the term hopeless more generally than just in relation to a couple of prayers for relief. But they seem to have hit home in some respects, because you've changed the prayers for relief in your new draft.
Oh, my lord, not as a consequence of anything that they've said in that respect. I'll come back to that. Not as a consequence of anything that they've said on that. And I'm not saying, again, I'm not saying that is the final version. In terms of the prayer...
Okay. But the point I'm making to you is that you have put this forward, it might be said, unkindly, in desperation, because you have finally realised 2.5 years later that the petition has a real problem with it. And the problem is that there was no obligation to offer you shares in the shareholders' agreement, nor in the articles. Now, if you are right that Article 3.2's exceptions do not apply, then that obviously would change the reader's mind. But without pleading that, and without explaining how it is that it is the case...
Well, we've pleaded that 3.2 applies. We will be hit, or met, no doubt, with an argument that they won't apply.
But at this late stage, since you knew that you've just shown us that in their rejoinder they made it perfectly clear not only that 3.2 didn't apply, but also you agreed to it being filed, giving the reasons why.
Yes.
Now, when sitting in the Court of Appeal on day 1.5 of a 1.5 day appeal, you need to tell my lords and me why this adds up to the beans that I asked you about yesterday.
My lords, the difficulty here is I'm seeking to explain, on the one hand, this is not a final document, and on the other hand, seeking to address some of the points that my lord is making as regards what you regard as its deficiencies. In relation to 3.2, we have pleaded 3.2, and that's what the petition, we say, would contain, and it's already in the reply.
Where is 3.2 in the bundle?
3.2 in the bundle, and I stress, my lord, this is the 2011 articles. 3.2 in the bundle is at page, it begins at 105, and it's at page 118.
That's of the sub.
Sorry, yes.
Right. And it changed between 2011 and 2000.
They've only, I think, changed in terms of the reference to special resolution, which may have changed to special shareholders.
It's changed
majority.
more. I think it's changed more. I mean, I when I saw that rejoinder, and it referred to,
yes.
I mean, the very first share issue, they said, one in February 2016, Article 3.2 was disapplied by operation of Article 3.7.2b.
Yes,
thought, well, let's have a look at that.
Well,
it's not there.
I know. I did
So,
the same. I did the same.
Yeah.
I did the same.
So, I mean, the answer is that, as it were, oh, actually, there is a 3.7.
There's a
I'm wrong about
3.7.2,
that,
but not B.
Not B, that's
Yeah.
the point. That's the point. Yeah. But the structure of it may be similar. We don't know, of course. But the point is, it opens, doesn't it, with the words subject to
Absolutely.
Articles 3.7, 3.8.
Yes.
Blah, blah, blah. So, I mean, you don't get into 3.2 if any of those apply.
I accept that. I accept
So
that.
you have to show they don't apply in order to get into 3.2.
I keep coming back, my lord, to the point.
And a special resolution.
We have,
Well, that's an
exactly,
alternative.
but there is an issue about the information that we have had at the time of those transactions.
Well, I appreciate at the time. I understand that. But I'm at the moment not convinced, don't see how I could really be convinced, that you haven't since acquired the information.
In which
in
case,
time to plead it.
in which case, my lord, that is something that if I had sufficient time, may well appear, but we have not had time overnight to do that.
Right.
We have not had the time overnight to review.
No, you haven't. No, of course not. Of course not.
And if my lords are saying, well, 3.2 needs to be, the references to 3.2 need to be beefed up because it's not sufficient to simply make a positive assertion that 3.2 applies, wait for the other side to say it doesn't apply for the following reasons and then respond to that in the reply to say why those reasons in the defence.
Mr. Chasty, it's not a technical issue. This is a substantive issue. And of course, we need to focus on the technicalities to make sure that they don't invalidate a commercial, substantive view of the case. But what is being said against you that you need to tackle is this case is hopeless. And it's hopeless because you had no right to buy any further shares in this company. Not only did you not have any right, you knew you didn't have any right. You agreed to a, whatever it's called, deed of accession, which waived those initial rights that you had, and you knew that you were in exactly the same position as any other investor, and you would either get them or not get them in a free market competition. Now that's the issue which I need to be persuaded you can get over, and if you persuade me, then of course, no doubt, your pleading in whatever form after whatever consideration will be absolutely fine. But at the moment, it seems to me that the sort of the fact that gets you over that hurdle has not been identified.
Well, look, my Lord says technical issues and then substantive issues, that my Lord's taking the view that we have a hopeless position.
No, I'm not. I haven't taken any.
No, I'm sorry, my Lord. You're expressing that.
That could be.
I'm using I'm using a
Mr.
shorthand
Ashworth says.
just to make the point, my Lord.
Yeah.
But my Lord, what I would stress, in fairness to my client, and actually also those acting on behalf of Zedra, is that we came to this court to fight technical issues, we say. The substantive issues was all the stuff about the human rights. That was the substantive issues that we came to fight. The technical issues were whether or not this pleading on bad faith was sufficiently particularised. And
that is the point. I mean, you're saying that this is all new, but you're quite right. That is the bull point. Is there a sufficient pleading of bad faith and improper purpose in paragraph 37?
But
this is, and so we were looking at those sub-paragraphs and really concerned to see how that case could be deduced from what was
when I say it was even more, if I may, if that's the right way to try to describe it, technical than that, because it was whether or not to plead an allegation of bad faith was sufficiently pleaded. And that's why we were arguing about Three Rivers and fair balance, and that's why my friend's appeal is all about subjective minds of individual conspirators and so forth. That was the case that was being advanced against us.
Well, we have the point that the fundamental issues that arise in relation to bad faith were never part of the appellant's case. That doesn't make them any less fundamental.
No, it doesn't, Morg.
Both sides came, as far as I'm speaking for myself, both sides came to argue about technical issues. Actually, what we're looking at is the fundamental parts of the claim, whether they can be sustained. I completely take the point that was not what was raised in the detail of the submissions by the appellants, save for piggybacking on to the point that my Lord's just made about the bad faith generally.
My Lord, what I say then, against, if I may, against that analysis of how we got to where we are, that this, with in our respectful submission, is procedurally unfair on my client to be facing now these questions from the Lords, which have not been advanced by the appellants, and done our best in very short time to address some of the points. And I'm stressing that they are not the final word, but my Lords, with respect, are seeking to make me tell you what my final position is.
Well,
we would respectfully say we're entitled, in the way that this has arisen, to have time to do that.
Mr. Chasty, this court is preeminently keen to ensure that there is no procedural. Forgive me for saying, 2.5 years after starting the case, one might have thought that you would address, in at least in my mind, the central question of, is there really a right I had, and can, if not, can it be said that as a lack of benefit respondent, because two are intimately connected, as the law has indicated. We have spoken about lack of benefits this morning very much, but the reason we're focusing on the right is because there was, you had the right, then it follows that it is likely that the verified is not giving that right. So what I'm asking, and this is without prejudicial, whether they're going to be allowed to make the amended case, or whether indeed the original case included this part of the allegation, do you have a clear answer to it? And at the moment, it's not really an answer to say, well, there may be an answer which I might find if I had more time, because you've had all this material for ages. And so if your case is, and it may be, none of these things that they pleaded in the rejoinder are properly exceptions to Article 3.2. So we did have a right which has been overborne, and that makes it bad faith, then say so.
Well,
If it is something else, also say so. But at the moment, it's even this new pleading seems to me, at first sight anyway, to skirt around the sort of adds a lot of stuff, but it skirts around the actually absolutely fundamental point.
Okay. My Lord, I'm fearful I'm just repeating myself, but can I just make this last point about what my Lord has just said in respect of that? You said we've had 2.5 years about this. Just put that into context with what's been happening with this matter. We put our pleading in, and they responded to it. We put our reply in, and then on the eve of the application to strike out certain parts, they applied to put their rejoinder in. And then everything stopped because His Honour Judge Eyre refused to strike out, and they launched an appeal. So the CMC was moved, everything stopped, and we all waited for the appeal, which took, as my Lord I think observed yesterday, longer to come on.
Actually, it wasn't. It was. I was a little mistaken about that. Lady Justice Aspin gave permission in July, which is always a bad time because you lose 2 months in the long vacation. So it took 10 months, but it's a little bit longer than one might hope. It would be a bit shorter now.
But there was a period of time when we were taking the position, we've got an appeal, and we see what the grounds of the appeal are, and we know what we think about the majority of those grounds of appeal.
Well, yes, I see this point. I mean, what you're saying is you had no real, you had no reason to think you'd have to think about it.
No.
But you might have just anticipated that a 3-judge Court of Appeal might look with care at your petition.
Not at all, my Lord. We thought that, bearing in mind that the appellants themselves were not taking any point on any of this, and that the pleadings were effectively closed subject to the strikeout, and there'd been some RFIs and they'd been answered, and we were all gearing up to a CMC, that there was nothing to indicate that we needed to spend the time thinking and therefore coming to be prepared. And my Lord, so just going back, if I just...
I mean, I do take that point, Mr. Chasty, although I think there's sort of two sides to the story, but I do understand how you got where you are.
Thank you, Lord. And so finally, just on this, just to address this point, Lord says, well, you've had plenty of time with the rejoinder and time to decide what to do with the rejoinder. So far as this has sort of emerged yesterday, I've had 24 hours, and there will be information and there will be answers. And it's important that we should have the opportunity, properly with our client, to address them.
I mean, the thing which is surprising to me, actually, the thing that's surprising to me as a practical matter, is that having been given the draft rejoinder in June 2019, with answers as to whether or not the issues of shares were permitted under Article 3.2 by virtue of various exceptions, you didn't actually look at, not you personally, but your client, Zedra's legal, didn't actually look and say, well, are these right or wrong?
But my Lord, I can't say whether the trust and those...
It'd be very surprising, wouldn't it, if they hadn't had a look at it. And you haven't come back with anything saying there was a breach of the relevant Article 3.2 because the issue didn't fall within any of the exceptions, in particular not the one relied on in the rejoinder.
But overnight we've not had the opportunity.
Not overnight you haven't. But I'm just saying, Mr Chasty, it's nearly 2 years since your client had this document, and I just find it, in a claim of this size, extraordinary that nobody on your client's side has had a look at it and asked themselves the question, are they right or wrong about these points?
But I don't think, my Lord, we can say that nobody on my client's side has failed to do that. The point I'm making is that since this time yesterday, we have not been able to address those matters with our client, to address the specific questions that the Lords are now raising.
Yeah, it was a pretty fundamental point, that's the trouble.
I don't underplay the fundamental importance of it. What I do state and stress is the question of whether or not deal with all of these points on the one hand, and trying to also then, in the space of time available, to deal with anticipating responses to the rejoinder is not an easy task to do. And I'm going back to the same position. My Lord's got that point.
Okay, but I think we've got the submission. Yes, thank you.
Well, can I just take?
Yes. Do you want to say anything about the prayer?
In terms of the prayer, does my Lord mean in terms of what we've changed on the prayer?
Yes.
Again, I'm putting forward these again, not as final words, but in respect of 2 and 3, one can see that and again, this is most likely to reflect what would be that those claims for the prayers at 2 and 3 would go in the light of the IPO. But it wouldn't follow from that we would want to take out those paragraphs 27 onwards and 33 onwards.
No, because you say they support
they go
your
to bad
bad faith argument. Yes.
Yeah. And then 4, 1 and 2 are reflective of that. And then so far as 4 is concerned, just by way of a general observation, this is the indemnity point. 4 is for the directors involved in the breaches to pay equitable compensation to the company for the breaches, and out of that for the company to compensate Zedra. And then you can see that 5 is really actually an alternative, that the directors involved pay to us directly. So far as it was suggested by Mr Ashworth that 5 should fall if 4 would fall, we would say that's completely wrong. 5 really should stand, and there's no jurisdictional reason why 5 should go. In terms of 4 is really there in case, as it were, a court ordered the company rather than the directors directly to pay any compensation that we're entitled to, rather like a company might be ordered on a share buyout to buy the shares as opposed to the individuals being required to pay the shares. And we put it that way, and this is why I think the judge was right to call it in the way that he did, effectively an indemnity. We're saying in the event we asked the court to order that, we put it into the frame. May well be that the court didn't order the company to provide that compensation, but if it did, then so as to ensure that there was no damage or detriment to the others, then the other respondent should reimburse.
Yeah, I understand, I think, what you're doing there. You're saying if the judge says, look, if you like, as a technical matter, it seems to me the compensation should come from the company,
yes,
not from the individual directors. You say, well, then please order the directors to pay the relevant sum to the company, and out of the proceeds,
yes,
the company compensate us. So you're not seeking an order against the company which goes further than what the individual directors would be required to pay. And so it's just to meet some technical argument that the relief should be against the company, not against the directors. Yes. That's the point.
That's the point.
Yeah,
and then in respect of 5, and again this might require some revisiting, but we've tried to answer my Lord's point, I think, which was raised yesterday, about when is it that you're talking about in terms of restoration of percentages.
Yeah, that makes it clear.
And then, as I've already said, my Lord, 7 and 8, they're not the subject of this strikeout application. So we're going to have...
You've addressed dilution at 6, which is helpful.
Yes.
And 7 and 8 are not strikeable usually.
Well, they're not even the subject of the appeal.
No. Okay.
Well, they weren't the subject of the original application, save for the first claim, the strikeout, which was everything, but that failed, and that's not renewed before us. So
exactly. So we're going to have a trial on those matters.
Right. So is there anything else?
Lord, no.
No. Thank you very much.
Peter. Thank you very much, Mr. Stacey. Mr. Ashworth.
Well, can I deal first of all with an observation from Lord Justice Coulson, where it was suggested in passing that our grounds 1 to 3 were grounds which were not run below. With all due respect, they were. We ran the argument below that there was no power to make the order which was sought. It was the allegation was not run below was not a point made in the respondent's statement. pursuant to 52 CBPD 19, which is where one would expect that to be made. And my lords, can I give you some, I can take or give you some transcript references to show that we did indeed take the point below.
Well, I think
What,
it
the
may
A1,
be,
P1 point?
yes.
My lord, yes.
You took the A1, P1 point below.
My lords, we did. The express references was at 237F to 238D.
Just a minute, hold on.
237 of what?
Sorry,
Transcript.
supplemental bundle, my lord. In the transcript, 237F to 238D.
237F to 2. F.
D, my lord.
And a B in the next page is simply a breach of the first article on the first protocol.
My lord, yes.
Not particularly developed.
My lord, I did not put before the court the medical asbestosis case.
No.
But it seemed just to respect.
So that one sentence justifies 3 grounds of appeal.
Well, my lord,
It was not a point that was fully and properly put. I don't think it matters, because I think it's a duff point anyway, but speaking for myself. But it's simply an illustration of the whole way in which this has been allowed to develop, so that we get to the point that I put to you first thing yesterday morning, that we're in the Court of Appeal arguing about pleading points. Actually, it's now apparent there's rather more substance to some of them, but those points have arisen from the court, not from the appellants.
my lord, the grounds of our appeal is that there's no power. And we argue the no power. We refer to the A1P1. We did not develop by reference to case law authority the A1P1 point in the detail we have done in our skeleton for this court. But I don't wish it to be said, my lord, this is a point which we did not take below, and therefore we fall foul of singing das on that. My lord, on the suggestion that the no unfair prejudice is a new point, you were taken by my learned friend to to page 163A of the supplemental bundle in that same transcript. You take the sentence at the top.
1, 2, 3.
163A, my lord, sorry. You take to that first sentence. My lord, that was taken entirely out of context, because it's in the context of discussion as to the distinction between derivative claims against a 994 claim, whether a claim for breach of fiduciary duty can found a section 994 claim. If one goes back to page 160F, which is where this passage started, my lords will see just above F. Next, my lord, we can turn to subparagraph 4 of the prayer, which is the out of the proceeds, the director should pay for compensation for the breaches of duty, and out of the proceeds, a Zedra should be paid. And then at 161 at F, my lords, I'm talking about the statutory fiduciary duties owed to the company, and refer to paragraphs 27, 37, and 44 in respect.
Sorry, you're losing me a bit.
Sorry.
Where are you going now?
161F, my lord.
161F.
161F, my lord. See, it says, Mr. Ashworth, the statutory fiduciary duties owed to the company. So
Yes.
just mention paragraph 9, which is the pleading of the duties owed, statutory duties owed. Then we talk about 27, 37, and 44 in respect of the acting in breach of the duty. And then at 162A, I say, my lord, therefore, this is clearly an undisguised derivative claim or possibly effective loss claim, which is not allowed either. So that's the context for this discussion. His Honour Judge Eyre QC says, I'm not sure I quite follow that because it is, if not commonplace, not uncommon in 994 proceedings for part of the unfairly prejudicial conduct to have been misfeasant acts by those in control of the company and those who breached the obligations owed to the company, but are at the same time also capable of being unfairly prejudicial conduct. And then 162E to the bottom of the page, my Lord, there's a discussion about the remedy, i.e. you don't get damages for an unfair prejudice petition.
But I mean, how does that help you? I mean, did you say that the petition itself was ill-founded?
My Lord, we did. I was going to come on to that. Right, but can I just find my reference, my Lord? 247E to F.
Just give me that reference again.
247.
247.
Sorry,
Thank you. I got it.
my Lord.
So this is you in reply,
This is me in reply.
right at the end.
My Lord. My Lord, we say strike the whole thing out. It's clearly the right thing to do. Paragraphs 1, 7 and 8 are massive contract. The rest are matters that are simply are hopeless in terms of the strikeout test. If you're against this, then we have to have bad faith and improper purposes go. And proper purpose and bad faith go because they're just not particularised, and the rest of the case goes. Because it all flows from that. So it all goes one way or the other.
This is what the judge deals with, doesn't he, in his judgment? We looked at the pages yesterday, I think. Find it again. At paragraph 79 and following, the pleading of the allegations of bad faith and or improper purpose. Is that,
My Lord, yes.
That's what he deals with there.
Yes, yes. So, my Lord, we...
Mr. Ashworth, can I just put this to you? If, my Lord, the Master of the Rolls is right, that the fundamental point here is that your clients had no obligation to offer the respondents any of the shares, and that therefore, when the new share allocations happened, and that's a potentially fundamental difficulty with this whole claim. Was that ever said to the judge? That it should be struck out because it's all an attempt to get round what is plainly an obligation that isn't there?
Sorry, I'm being very, very slow. I'm sorry. We said to the judge below that you can only, the only way you could possibly get an unfair prejudice petition up and running here is if you can establish bad faith and or improper purposes. We said bad faith and improper purposes are the same thing in this particular case, and the judge is with us on that. And we therefore said the whole, without the bad faith, you cannot possibly begin to run a claim under paragraph 44, the dilution or the now diminution. Okay. So we said that quite clearly, my Lord.
What there could only be bad faith if there was an obligation on them. I mean, in the circumstances of the case that we don't need to enunciate in this question, there could only actually be bad faith if there was some obligation on them which they were skirting round in some improper way. Now, did you say that?
No, my Lord, I did not say that because I don't accept necessarily the premise of that, because one can have rights being exercised, which are strict rights, which are an obligation, but are exercised in bad faith. I think.
Well, you can, but in this context, it's really difficult. I mean, as my Lord has pointed out, you know, the law of companies is quite an area of strict operation, and if you're entitled to do something, I mean, this was my Lord's question at about 10:35 yesterday. If you're entitled to do something under the articles, then you're entitled to do something under the articles. You've got to go a long way to say that you did something you were entitled to do under the articles in bad faith.
Well, I think that in the discussion yesterday, Lord Justice David Richards was saying in respect to the article, the paragraph 37 argument, which is there as an example of bad faith, the original petition is there, itself could be something which was done in accordance with the articles, but with them deliberately being kept in the quiet. And so it is possible, and we viewed it as possible, that you could have something being done in accordance with the articles, which, if there was some bad faith, you convert that into a perfectly proper exercise. So your Lordship says dilution.
But that looks at it at completely the wrong end of the telescope. That's a possibility. But the real point here, it appears to me at any rate, is this question as to whether or not there was an obligation in the first place. And that doesn't seem to have been, it's not expressly pleaded in the defence as far as I can tell. It's not a point that's been was raised with the judge.
It is expressly pleaded in defence. We denied there being any obligation.
Oh, there's denials galore. But nowhere does it say that your whole case is an attempt to get round an obligation you don't have.
Well, I mean, isn't it right that there is, in the petition, there is no pleaded obligation? The petitioner doesn't plead that it was entitled to be offered the shares and that you then evaded that obligation.
It doesn't matter.
I mean,
So that didn't occur to you, that was actually on analysis what was happening?
Well, not in those terms, no.
No, that's...
But I said it's all within the bad faith complaint.
it's paragraph 44, isn't it, of the petition?
The original paragraph.
Sorry.
The original paragraph 44. And the way it was pleaded there was not that in 44.2, which at the moment I'm inclined to think is really the critical paragraph, it's not pleaded as an obligation that they offer, that the directors offer Zedra shares, just as pleaded that they didn't.
Dino,
And I think that is this is why the absence or presence or absence of an obligation is so important to the allegation of bad faith. So if there wasn't an obligation to offer the shares, your argument before the judge, as I understood it, was how does that create, how does the fact of not offering itself ground bad faith?
it does.
I mean, of course, it would be differently, even if there weren't an obligation to offer, if in fact they had, within the limits permitted by the articles, the directors within the limits permitted had issued to themselves shares at an undervalue but excluded, in particular, Zedra, then that would be an example of something being technically permissible, but an exercise of a fiduciary power or statutory power in bad faith.
Yes. And so, my Lord Justice Coulson, we did respond to it to say it's denied if it is alleged that the respondents were obliged to offer Zedra or any other shareholder such
Where is that?
opportunity. Paragraph 60, subparagraph 3, at page
60, yes.
page 137.
Yes,
Which was the paragraph that then gave rise to the request.
No, my Lord. That was...
That's 63 in brackets.
sorry,
Anyway, sorry, I interrupted you. Where was that reference in the defence, just for my notes? Paragraph 63 at page...
60, subparagraph 3, my Lord, page 137. We admit we didn't,
Yeah.
given the opportunity, we say tonight, if it's alleged there was any obligation.
Well, I can see why you said that, because you're pleading in relation to 44.2 and in relation to 44.4, where it could be said that there's also a sort of implicit suggestion that there might have been some obligation to do something. There's been no concerted attempt by the respondent directors to prejudice Zedra's interests, let alone an attempt to prejudice such interests for an improper purpose, and you deny the legitimate expectation. So I get that, both of you, but you're dancing around the main point.
Well, with respect to anything, my Lord, because the absent bad faith, there is no way that this allegation could have survived.
I think everybody agrees about that.
Well,
Although
so if we
if there
attack
were an obligation to issue shares and they didn't issue the shares, if there were a real obligation to issue shares and they didn't issue the shares, then they wouldn't need bad faith. They would have been unfairly prejudiced.
well, that's right, Mel. But that's why we attack the bad faith, because absent the bad faith, this cannot go anywhere. Because there is an assertion of concerted attempt, etc. And to prejudice their interests. We say no, there isn't, and you've got no bad faith. You've got to tell us why it is you say this is happening, and you haven't done that.
Well, it just goes to show, in my view anyway, the danger in eliding, in a pleading, the really substantive point in issue in the case. And sometimes pleadings do this, and it's a shame. Because the petition should have said what allegation it was making about obligation. And perhaps you should have been very clear about that there wasn't one before you got to the rejoinder. But anyway, we're there. We are where we are.
We are. But it comes, first, your Lordship will have to decide whether or not my ground 4 covers this point or not. Can I succeed on ground 4 because he says no bad faith, therefore there's no maintainable claim of unfair prejudice, therefore it goes. It's only if you say there is a maintainable claim of bad faith that we need then to get into the new ground, which is that even if there's a maintainable allegation of bad faith, which we say there can't be, then it fails anyway.
So your submission is it's only if your ground 4 on its own terms fails that you need your new ground.
My Lord, yes. Can I take you back to the new ground?
So is it sort of 4A?
My Lord, yes, however you wish to number it.
Yeah, but it would come in because you say if you're right about 4, that's that. But if you're wrong about 4, then you say it's this.
4A, yes.
Yeah.
My Lord, yes.
Understand that.
And so we set out what the judge should have done. And then we say, which in fact was no allegation of bad faith, it's not properly maintainable. Alternatively, even if which is denied the allegation of bad faith in relation to dilution in paragraph 44 of the petition is maintainable, complaint is constitute a maintainable allegation of unfair prejudicial conduct, because the company received good value for the shares it issued, and Zedra does not allege it had any right to purchase the offered further shares, whether under the Articles of Association or otherwise. So, my Lord, in response to your Lordship, Lord Justice Coulson's response, that is new. Except in those terms it is new.
But it's difficult to see, I must say, how it could be said there was bad faith in what the directors did, and yet there was no unfair prejudice. To you. And that's the premise, isn't it, of this second sentence. Alternatively, even if the allegation of bad faith is maintainable, therefore may be proved, even if it's proved there was bad faith, there can be no unfair prejudice.
That's right, my Lord.
How does that, but that, going back to the discussion we had 5 minutes ago, I don't see how that works, because it's postulating, isn't it, that although there wasn't as a matter of legal entitlement a right for Zedra to be offered shares, nonetheless the directors exercised their powers in such a way as to, in bad faith, to exclude Zedra, i.e., for example, by issuing the shares to themselves when the company didn't need the capital and things of that sort.
Well, that's right, my Lord.
I mean, but
that's why we say it doesn't work.
well, I'm sorry. The point I'm putting to you is why doesn't it work if bad faith is established?
Well, my Lord, because on this analysis there is no obligation.
Oh, but I thought that was the point we had. You don't need an obligation. I mean, the directors have an obligation to exercise their powers in good faith.
My Lord, yes.
If they exercise them in bad faith, particularly if Zedra and its beneficiaries are the targets of that, then that is both a breach of fiduciary duty and arguably, unfairly prejudicial conduct.
My lord, I accept that, but if there is no obligation, so if they're alleging, if the court were to hold the bad faith, you can simply say the directors jointly did this, and that is bad faith. But if the underlying obligation is one which could not give rise, or the underlying allegation is one which could not give rise to a claim in unfair prejudice, bad faith wouldn't take it any further.
Well, I'm just not really following that. What bad faith are you postulating here will be established?
I'm not postulating any bad faith.
Well, I mean, the bad faith they allege is that the directors exercise their powers in bad faith.
Let us assume, my lord, that all they've got is a right to be involved in the discussion, which is how it was being put yesterday.
No, they're saying that the directors exercise their powers in bad faith.
Sorry, my lord. Assume that the entitlement which the petitioner alleges is the
No,
entitlement.
supposing they didn't have any entitlement. They had no entitlement to be involved in discussions with anyone. But the directors say to themselves, we want to minimise this chap's holding. So we'll exercise our fiduciary powers of issuing shares in a way which achieves that result. That would be bad faith.
My lord, yes.
It would also be unfair prejudice, wouldn't it?
Yes, but I'm saying on the way this is pleaded, my lord.
Well, the trouble is it's all pleaded as bad faith. And if you establish bad, if they establish bad, I thought you accepted that if they establish bad faith, they would have an arguable shot at unfair prejudice.
I said they certainly can't. They can't have an arguable shot unless
Because of
they establish.
that I understand. What I don't understand is the converse.
Well, this is the new point, my lord, that it's being said that even if somehow there was bad faith, so assume the obligation is paragraph 44 is pleaded now, 44.2 pleaded now, as explained by the learned friend, that this is a right to participate in discussion.
No, but I'm sorry. I'm awfully sorry. This ground of appeal is not addressed to the draft pleading we've been provided with this morning. This ground of appeal is addressed to the existing petition. So there's no point in referring to it.
I wasn't referring to it, my lord.
Oh, sorry.
I'm sorry,
Right.
I've made myself.
I thought you were.
I'm looking at the old 44. 44.
Yeah.
I said the old.
All I'm trying to do, sorry, Mr. Ashworth, is to give you an opportunity of explaining to me how that second sentence of ground 4A works.
Because if they had an obligation, they had an entitlement to participate in the discussion.
Well, why did you say that?
No, if that's that's how it's explained yesterday as to what 44.2 means. But they didn't have a right.
I see. You're relying on that.
They didn't have a right to participate in the share issues, was
Yes.
yesterday's position. They had a right to participate in the discussions. Assume we, in bad faith, didn't include them in those discussions. We say, because that discussion goes nowhere, that entitlement discussion goes nowhere, then they can't make out unfair prejudice.
I see.
Even if they acted in bad faith.
Even if they act in bad faith.
Well, I mean, that's a very strange submission, because if directors act in bad faith so as to prejudice the interests of a shareholder, deliberately, one would have thought that's sort of what unfair prejudice is about.
I mean, if one looks at 44, it says that the company and its directors, really the directors, acting in bad faith and or for an improper purpose, have taken steps to dilute Zedra's minority shareholding, which is a breach of duty. Now, if they have been acting in bad faith to dilute Zedra's minority shareholding, let's say in deliberate breach of their fiduciary duties, to dilute, and that's what they mean doing, why does that not give Zedra a claim under Section 994? Because what goes on is dealing with bad faith. We've gone round that house several times.
Well, that's why we say that if you get rid of the bad faith, it's what we've always
but
done, you get rid of the unfair prejudice.
But that's what, right.
That's my original ground 4.
Indeed.
It's my ground 4A, because in case your lordships decide...
I'm just trying to understand the second sentence, the alternative, and I'm not quite there yet.
My lord, it's simply that because of the way it is pleaded, Zedra does not allege it had any right to purchase or be offered further shares. whether under the Articles of Association or otherwise.
All right. Okay.
It can't give rise to a claim.
You say that in fact it would never have resulted in them getting any shares.
At all, my lord. For the
That's a
discussion.
sort of... Right, okay. Yeah.
My lords, can I take you back to paragraph 41 of the petition, which is at page 113. Now, as things stand on the current pleading, and as explained yesterday,
Sorry, just give me a moment. Where is it you're taking?
page 113, my lord,
Yes,
in the callback.
I've got it in here. Yeah.
Paragraph.
41, my lord, the
Oh,
share
right. Yeah,
issues.
yeah.
Yes.
As explained yesterday, Zedra does not take issue with any of the share issues. It was not part of Zedra's case that any of them were to undervalue and so on, and they made no allegations as to the individual transactions themselves. It's just the fact that we are not a party to any of this. And that's in the transcript of yesterday at page 69, lines 20 to 27. So that was the situation yesterday.
You have a transcript
Yes, so
of
we...
yesterday.
Yes, we emailed it to you all.
Oh, right.
I'm
I think it probably arrived after I... Don't worry. Probably arrived after we came to court.
I'm sorry,
Don't worry.
it came last night, I
Oh,
think.
did it?
my lord.
Okay.
Um,
Okay. Well, it was emailed to our clerks, was it?
Yes.
Yes, okay.
Thank you. We emailed it to the Master Rolls clerk.
Oh, well, it'll find its way. That's fine. Thank you.
It went to the General Office email address as well.
Okay.
So that was what was said yesterday. We note it's now claimed...
Which was the reference? 67 what?
Page 69, my lords, lines 20 to 27.
Right, well, neither of my lords have got it, but
I'm sorry.
my Lord Justice David Richards asked, it is true, is it not? You do not actually take issue with any of these share issues. It's not part of your case that any of these share issues were at an undervalue and so on. Mr Chasty said no. So my Lord said, so they were all proper share issues as far as your case is concerned. We make no allegation as to the individual transactions themselves. It's the fact that we are not a party to any of this, that's the point.
Lord, yes. So as of yesterday, there was no complaint made about any of the transactions. For example, being undervalued.
But as of today, they now say that they were in breach of Article 3.2.
Well, my lord, they go further than that, because they say it in paragraph 41C, page 19, that two of the transactions were at an undervalue. But taking away yesterday's position, that's important, because absent bad faith, they can't be any complaint about. May I just correct one potential misapprehension? None of the transactions in paragraph 41 involved a share issue in return for acquiring a company.
All right. They were all for cash.
They were all for cash in order to purchase companies.
I see.
Rather than, when your lordship was putting to Mr Chasty, Zedra
Yes.
didn't have that to sell, which the others did.
No,
doesn't actually-
thank you for that.
Right. Yesterday, of course, we also had the assertion that there was no breach of the articles alleged. And now we have 3.2 being alleged to having been a breach. Paragraph 44 in particular does not, in the current pleading, does not and cannot assert that it had a right to participate in share issues. At one point, Mr Chasey appeared to suggest it did, but then seemed to row back, asserting that the rights were to have the information and to participate in the discussions. He said we were denied the right to at least participate in the question of whether or not to acquire shares. We were just cut out of that exercise at all. And my lords, that's transcript, page 60, line 32. And that is not sufficient. Without a right to participate in shares issues, there can be no claim of dilution in any prejudicial sense, let alone unfair dilution. Zedra does not and cannot claim that in its petition. can I invite you to note what the pleaded rights are in that particular version of the petition? Paragraph 16, my lords, page 102. So you were taking this, setting out the rights that arose, supposedly under the SPA. And it'll refer...
So where are you now?
So page 102, my lord, in the core bundle.
Right, thank you.
And you will recollect, too, that its rights to shareholding were protected by Nabahar-Cookson's continued participation as a member of the board. And I think your lordship asked the question whether under the SPA he had an entitlement to be appointed under the board. In fact, my lord, if one goes to the supplemental bundle at Article 11.6, which is at page 129 of the supplemental bundle,
£129,
29, my lord.
thank you.
You'll see that Article 11.6 gives Zedra, a director appointing member, the right from time to time to appoint up to 2 people to be director of the company and each other group of the company. Zedra chose not to appoint a director.
So Zedra fell within the definition of a director appointing member.
They did, my lord, yes.
And has, I mean, did we of course haven't got the subsequent articles, but did this article disappear at some point?
No, this remained until listing, my lord.
Until this.
So until listing, they had this right.
Right.
So Mr Cookson resigned. He then had a substitute director who was there for a while. He resigned.
Yes.
In the whole period of which complaints now
Yes.
made, they chose not to put a director in. They
Yes.
subsequently chose to put a director back in 2020, and indeed Mr Cookson himself was reappointed for a while in 2020 until the listing. So they've always had that right to appoint a director. So when they complain of being shut out, there's no allegation saying you did not let us appoint that director. So it's very difficult to see how they could be denied anything, access to anything. At paragraph 20 of the petition, at page 104, I think this is the point Your Lordship, Lord Justice Richards got out of Mr Shenson's judgment. So
Sorry,
paragraph 20,
which paragraph? 20.
20, my lord, page 104, the core bundle. And he sets out, pursuant to clause 7.1, covenants with the shareholders, sorry, the company covenants the shareholders in terms of covenants in Schedule 3 to the SHA as amended by the deed of adherence. And then pleads particular respects in which it is said that the rights it has under that. I invite you to turn to the shareholders agreement, which is in supplemental bundle at tab 10.
Anyway, shareholders agreement, yes, at tab 10.
Tab 10, if you go to page 89, my lord. And the rights he got were 1.1, 1.3, 1.11 and 1.12. He expressed he did not get the right under 1.2 or 1.7. So not only did it have no entitlement to participate in share issues, but in fact didn't even have to give its prior consent to the issuing of any other shares under 1.7. So, my Lord, I think this is the point that Lord Justice Richards was making,
Yes.
I understand it, about
Yes.
the new pleading effectively trying to put in an implied right entirely contrary to the express right.
Yes.
And it is right that as the Master of
That was not argued before the judge.
Sorry, this is in the new...
Yes, no, but I mean, it wasn't said that there was no, that all this legitimate expectation was countermanded by the absence of any express right.
Well, because they didn't allege a legitimate expectation of the right to
alleged,
participate in shares.
They alleged a sort of, right, a legitimate expectation that the shares would be offered to them, and you didn't point to this article, to this part of the SHA.
I can't remember. I have it highlighted with a yellow sticky label on it, and I've taken this out of my previous bundle, my lord. Right. So whether I actually...
That's a bad sign.
Well, that would indicate I was intending to, my lord. But whether
I see it was highlighted.
It was highlighted with a yellow sticky label on it.
I see.
And this is my original bundle, my lord. But the point is...
That's what I might call analogue evidence.
My lord, I haven't done a search on the transcript to see whether I did actually refer to this.
Okay.
But the point is, my lord, that you said in discussion yesterday, Mr. Chasey, that he was trying to create a right which wasn't originally granted, nor ever has been granted. Indeed, it was completely contrary to the rights that were granted. And so, my lord, we say that it's impossible for them to formulate any right in their current pleading, or indeed we say in the new draft, which has been infringed, which could possibly have led to a loss. And we say that their attempts to find assistance in our defence must fail, because one's looking at the petition. So what does the petition say about it? And there is no assistance in our defence. We've already been to paragraph 60, sub-paragraph 3. So we say that the allegations of bad faith constitute the sole foundation of the unfair prejudice complaints. I said, as opposed to the contractual claims for breach of the information obligation, which form paragraphs 46 and 47 of the petition. And if the allegations of bad faith are not maintainable, the whole edifice of the unfair prejudice petition collapses, because there's nothing left to support it. And we said that in terms to the judge. And therefore, my lords, we say if we're right in this, there's no need to rely on the new ground. We are right on this because there is no pleading that can amount to bad faith in paragraph 44. And your lordship, the Master Rolls made the entirely correct point. There must come a point when a party subjected to fraud has been told about it, has to go back and say, hang on a second, don't do that again. Not only were they told about the issue of the shares on the shareholder, and we say that much is effectively acknowledged in their pleading at paragraph 44.3 of the petition, because they say, insofar as we consented, we didn't consent properly, i.e. we knew about it, but we didn't consent properly. But of course, each issue of shares was recorded at Company's House. But these are, my lord, the most open alleged fraudsters imaginable, if they're acting in bad faith in the way which is alleged. It was said that directors know what is said against them, that if any one individual director who's the subject of the claim wishes to step out and say, I see you've included me as part of the collective, but he did not do anything, then he would have been able to do that. But the defence is on behalf of all of the defendants. And that was in the transcript yesterday.
And presumably they had solicitors acting for them, city solicitors dealing with all these articles of association and obligations and everything else.
At the outset, my lord, yes.
Well, on both sides.
Yes. Well, Lord, not necessarily city solicitors. It was Halliwell's in Manchester who are acting on our side.
I mean, Halliwell's do corporate work.
Yes, they are big solicitors, my lord. These are not small solicitors. What I can't say is that the Zedra had solicitors on each of the share issues.
No, I don't mean Zedra. I mean, you're looking at your own side.
Yes.
And the company presumably had corporate solicitors dealing with all these share issues.
Yes, my lord, yes.
Yeah.
Absolutely. Not Halliwell's the whole way through because they suffered a demise in the middle of this period, my lord. So it's unrealistic to suggest one of the directors could step out and say, I've done nothing, because at the moment there's no particularisation as to what they've done. None of them say they've acted in bad faith. and they all stand together at the moment, resisting a case of bad faith, tantamount to dishonesty, on the ground that none of them were guilty of bad faith or dishonesty. It's because Zedra has seemingly failed to distinguish between them that they are able all to stand together. As things stand, on the amorphous and generic pleading, there's no conflict here at all between the parties, hence between the defendants, hence they can be jointly represented. But if this claim is allowed to continue on this basis, it's possible that sometime there could become a conflict if the allegations are amended.
What do you say we should do in the present situation, Mr. Ashworth? Assume against yourself that Mr. Chastey has now come forward with something sustainable, or at least that the court felt that it should accede to his request to have enough time to do so. I mean, obviously that covers a whole lot of issues, but let's assume against you that all those points go his way, and we now see the whites of the petitioner's eyes, and we understand that there is possibly a case that is in elemental form contained in his amended petition. What do we do?
Well, what you should do is allow this appeal to strike out those parts of the petition that I am seeking to strike out. Mm-hmm. That will leave the petition on foot because paragraphs 7 and 8, the information obligation, would remain on.
Strike out everything except paragraph 7 and 8.
And the bits that lead up to 7 and 8 in the prayer, my lord.
Yes.
And then they can make a decision whether they are going to make an application back at the High Court to the High Court judge seeking permission to amend, at which stage we will then be in a position to consider it and put in evidence on it. They have to put in evidence to explain what they're doing and why they're doing it. And we could put in evidence and say, well, this doesn't work. The Article 3.2 point, for example, my lord, we might end up with all of the various sets of articles saying at the relevant time, this is what we did, this is what we did. You haven't said why these exceptions do not apply. So, to His Honour Judge Eyre, I imagine, or one of the judges in Manchester, we say, well, my lord, this amendment should not be permitted.
It's a bit difficult there, isn't it? It requires quite a lot of sort of slightly, well, it requires quite a lot of detailed work to say what you're striking out.
Well, if you...
I mean, maybe it's just work's got to be done, but that you would leave not much, but you would leave more than just paragraph 7 and 8 of the prayer.
My lord, you leave
because your original application, absent the first bit, only seeks to strike out a very few number of paragraphs.
It did, my lord, yes. But then sought to strike out all the relief bar paragraph 2 of the relief.
But 2's gone. Well,
Two's
2 hasn't
go
gone,
in.
but he says 2.
Yeah.
He's happy to take 2 out.
But it was all, we sought to strike out the whole of the relief. So that's why we say the whole thing goes.
Okay.
Anyway, basically you say there's something left in the petition after you've applied your blue pencil, and that therefore there is a vehicle still just about rolling along the road which they could apply to improve, as it were, by amendment.
Yes, my lord. So I'm not saying you can say to Mr. Chastey, there's no prospect of that amendment at this time. It's got a number of very substantial difficulties in our view, but that's a matter to be addressed as and when an application to amend is made. But looking at the petition as it currently is, it does not work on these parts. And if you leave the information obligation, you have your limping vehicle, my lord. I'm sorry if that creates a lot of work to work out what's to be struck out.
Well, sorry, just so that I'm clear, your draft order,
Yes.
it's a bit of paragraph 27, it's a bit of paragraph 37, it's a bit of paragraph 44, and then large parts of the prayer.
All of the prayer bar, paragraph 2.
Pardon?
All of the prayer bar, paragraph 2, I think, and the interests and costs paragraph.
Yes.
Yeah.
I understand the points about the prayer, But the actual body of the pleading, it's really limited to the acting in bad faith and for an improper purpose.
My Lord, yes. And then, if need be, we'd have to apply for summary judgment if there's anything left on that. But we say there's a real practical purpose to this, my Lord, because although the information obligation remains as an allegation, one has to say, is it really likely that that is going to limp on by itself? So if they decide not to amend, they stand back and take a view of this, say, actually, we're not going to get this home. And the information obligation is going nowhere. Yes, in theory, it's still alive, my Lords, but it's no damages claimed, no loss is actually particularised. They've suffered as a result of it. And in the real world, the value is in the shares, £235 million worth of shares. So it's obviously a matter for them. We can't force them at this stage to abandon that.
You don't say we should put the whole thing to death.
My Lords, I don't think I can say put the information obligation to death. What I do say, and Your Lordships may, as a matter of case management, consider this, is that His Lordship, as Honour Judge Eyre, would not have allowed the information obligation to run but for the rest of the petition.
Does he say that?
My Lord, he does. He says it should be paragraph 97 and 98, page 95 to 96.
Sorry, paragraphs.
97 and 98, my Lord.
Thank you.
But you say we should.
Well, my Lord, I'm saying as a matter of case management, you might take the route that he was going to take, that if he struck the rest out, he said that ought to be dealt with as a Part 7 claim.
Well, but then that's really the whole reason I'm asking these questions, because that would be ridiculous if they got permission to amend, and not ridiculous if they didn't. So, what are we to do?
Well, my Lord, it may be that decision is to be made at a case management, or as I have an application for permission to amend. But if they seek permission to amend and they don't get it, then it may be that judge will then just give directions. He'll give directions to the running of the rest of the action. It may be say this should continue. He'll say this should continue as a Part 7 claim. But we can't stop them running the information obligation. We say it's misconceived.
Okay, let me ask you another question. What do you say we should do if we harbour the gravest possible doubts about the sustainability of even the new approach?
Well, you allow my appeal, strike out the petition, and then you make observations in your judgment, having seen the draft. It has various difficulties that would need to be overcome. But I don't think, absent Malone from making an application for permission to amend,
not much we can do.
it's not like your Lordships can do it.
Okay.
My Lords, I was going to pick up again the point that your Lordship made about the respondents here. So we've got a number of respondents who are not even directors at the time of paragraph 44 allegations. So Rachel Horsfield and Zilla N. Bing Maddy, 14th and 15th respondent. Mr Poach is only, who's a solicitor of the senior courts, is only a director for the very last of these matters, as were the 11th and 12th respondents who only got appointed at the time of the allotment of September 2017. So we say no claim can be maintained against the rest of them for the first 12 allegations, against those for the first 12 allegations and the two latter at all. And so there has to be, even if you're not with us and striking the whole thing out, there has to be some pretty robust rulings that they can't run allegations of effective fraud against people who are not parties to the acts at the particular time. And it's wholly improper of them to do so. And these are solicitors, independent directors, etc. These aren't the original people. Well, I think I've, on the new ground point, perhaps I should just deal with Das and C, points raised there. We say that those principles don't bar this being advanced. Firstly, those are principles applicable to a new point raised to the Court of Appeal after a trial. One can see that because it's talking about different evidence having been necessary, the trial being run separately, and that is not this case. Secondly, as to paragraph 18, the 3 points, we say that Zedra has had adequate time to deal with this point. It's always been our case that this is unsustainable. Not, as we say, under the new ground in that particular way, but it's always been the case. This is a very odd petition, however one looks at it, my lords. This does not look like a Section 994 petition that normally does. And we have made that our position clear about that from the outset. So they've had time to deal with it. As your lordship said, Master Royal said, it's not a complicated point. It has not acted to its detriment on the faith of our earlier omission to raise it, and the court's powers are sufficient as to costs if you were to find that it only succeeds with this ground and no others. If it's a bad petition, we'd still get the they shouldn't be allowed to run it, but they could be protected on the costs of the appeal, if that was the ultimate finding here, my lords. We say it shouldn't be.
So those are all points that go to 4A.
4A, my lord, yes. There's just the Das and Singh.
Yeah.
So it's the 3 points.
The
of
3 elements
18.
in Lord Justice Haddon Cave's judgment. Yeah.
Sorry, one point I ought to clarify, my lord. Lord Justice Richards raised yesterday the question of Section 232 of the Companies Act,
Yes.
where the indemnity worked. And your lordship, of course, is right. Article 14.2 of the articles says the indemnity only works as far as it's not otherwise prohibited by law. Section 232 of the Companies Act says you cannot, a director cannot have indemnity for breach of a duty actually found against him. You can fund a defence. You can make any payment on settlement, provided there's no admission of liability. The director can't rely upon the indemnity if there is a finding of breach of duty to the company by the court. It doesn't arise here, we say, because there's no claim for loss suffered by the company as a result of any breach of duty. It's the paragraph 4 of the petition. The company can also, my lord, take out insurance for the benefit of the director to cover that liability under Section 233. So if a director is liable for breach of duty to the company, the company can insure the director against that. That's allowed in Section 233. And it can also indemnify in respect.
But this just deals with a point, as I recall.
A point, my lord, yes.
I think you accept that that point probably doesn't run.
Well, my lord, not on its terms. There's nothing wrong with the indemnity as far as the claim is in reality a claim against the director by Zedra. So insofar as Zedra are making what is effectively a claim against directors, then there's no difficulty with the company indemnity working.
Well, I mean, this arose out of, is it paragraph 4 of the prayer for relief. So if the directors have caused the company to be in breach of a contractual obligation in circumstances amounting to a breach of fiduciary duty on their part, statutory duty to the company, the company is liable to pay damages for breach of contract. The company could go, couldn't it, against the directors for, in effect, for an indemnity compensation for breach of statutory duty, and Section 232 would prevent them from relying on an indemnity article.
My lord, if there was a claim by the company against the directors which sounded in damages, then yes. Subject, if the claim is by another party against the company, and the company then is trying to pass the liability on, the Article 14 indemnity won't apply, but we may be into Lister and Romford Ice grounds, whether or not whether it's right for the company to sue its employees.
Yeah, but anyway, reliance on Article 14 would be a problem.
In this particular case, it would, my lord. I wish to clarify that.
Yeah, thank you. All right. Thank
Your
you.
lordship was, of course, right. My lords, is there anything further I can assist your lordships with?
Thank you very much, Mr. Ashworth. Right, well, thank you both for your submissions. We'll take time to consider judgments, hand them down in the usual way, seeking typographical corrections, and we would ask when you receive the judgments to agree consequential orders and costs, and if you can't agree, we'll deal with those matters in writing. So it only remains for me to thank you, your juniors and your solicitors for all the hard work that's gone into this case thus far. Thank you.
All rise.